Today, the committee will examine Texas's SB 8, which Justice Sonia Sotomayor described as a flagrantly unconstitutional law engineered to prohibit women from exercising their constitutional rights and evading judicial scrutiny. SB 8 attacks the Supreme Court's long-established precedent in Roe v. Wade and effectively bans nearly all abortions in Texas, even in cases of rape and incest. It uses a civil lawsuit, a bounty hunter-style enforcement scheme that was designed to insulate the law from judicial review. Chief Justice John Roberts would have blocked the law from taking effect, calling the bounty hunter system, quote, unprecedented. But at midnight on September 1st, after skating through on the Supreme Court's shadow docket, Texas's SB 8 became the law in the nation's second largest state, stripping away constitutional rights for millions of Texans who live there. I'd like to show a brief video about this Texas law and what is at stake.
The Lone Star State's new abortion law, also known as SB 8, went into effect September 1st.
The law bans abortion after around 6 weeks, which is before many women even know they are pregnant, and it makes no exception for victims of rape, sexual abuse, or incest.
That's all women get. I have dreams and hopes and ambitions. Every girl graduating today does. And without our consent, our control over that future has been stripped away from us.
I didn't find out until I was 8 weeks. You're going to take that power away from me of being a rape victim at 13 and tell me you're going to have that child.
It allows for this kind of vigilante justice, this bounty hunter.
Allowing anyone to sue people who help women get an abortion, like a doctor or clinical staff or even drivers.
The Supreme Court decided not to block the Texas law in an emergency ruling called a shadow docket decision.
It's all happening sort of outside the ordinary court procedures, without the ordinary process and transparency.
The conservative majority's abuse of the shadow docket to overhaul the law has been raising alarm bells.
This is rough justice that can be used in any number of different scenarios, and it's a danger to everybody of every ideology.
It may become a model for action by other states. This kind of scheme to nullify the Constitution of the United States is one that all Americans should fear.
I hope you can feel how dehumanizing it is to have the autonomy over your own body taken away from you.
For nearly half a century, there's been a concerted campaign to undermine the Supreme Court's ruling in Roe v. Wade that women have a constitutional right to an abortion. Opponents of Roe have tried a range of legal tactics over the years to undermine this right. But past attempts by states to pass pre-viability abortion bans have been stopped by federal courts, which have blocked the states from enforcing these unconstitutional laws. The architects of SB 8 took a new approach. Instead of having the state enforce an extreme abortion ban, they put enforcement in the hands of private citizens who can be rewarded with a bounty of not less than $10,000. $10,000 is often publicized as what's at stake here. The statute expressly says not less than $10,000 court costs and attorney's fees. People who aid or abet under the statute, an individual in obtaining an abortion in Texas, can now be sued by anybody and everybody under this bounty hunter system. A disbarred attorney in Illinois has been one of the early plaintiffs who brought a lawsuit. One San Antonio doctor has been sued multiple times for providing an abortion to a woman who was in her first trimester. This type of private vigilante enforcement scheme is unprecedented. Texas lawmakers paired it with a clearly unconstitutional abortion ban in the hopes that it would shield the law from judicial review on the basis of jurisdictional questions about who could be sued to block the law. A group of healthcare providers did sue state officials in Texas to try to block the law from taking effect. And a federal district court scheduled a preliminary injunction hearing for August 30th. But on August 27th, the Fifth Circuit Court of Appeals stepped in and, without explanation, stopped all district court proceedings. The providers had no choice but to seek emergency relief from the Supreme Court with the clock ticking. This brings us to the role of the Supreme Court shadow docket. The shadow docket is a set of decisions and orders that the Supreme Court issues outside of its merits docket. These decisions are often rendered on short timetables with full briefing, public deliberation, and without full briefing, public deliberation, detailed explanation, or even signed opinions. In recent years, the Supreme Court has started to use the shadow docket for more political and controversial decisions, with results that appear on their face to be ideologically driven. A premise of the shadow docket is that emergency injunctions should be granted only when the party seeking relief is likely to prevail and irreparable harm is likely to result if the temporary relief is not granted. Recently, Justice Breyer in the Supreme Court published a book in which he argued that it's wrong to characterize this court as political. Justice Amy Coney Barrett appeared at the McConnell Center at the University of Louisville to make the same argument and to, quote, convince us that this court is not comprised of a bunch of partisan hacks. But listen to the numbers on the shadow docket and draw your own conclusion. Between 2001 and 2017, under the presidencies of President George W. Bush and Barack Obama, there were 8 shadow docket opinions in that 16-year period of time. 8. When President Trump's Justice Department requested emergency relief on the shadow docket, 36 requests by the Trump Justice Department, the Supreme Court granted it in 28 instances. 28 out of 36. But in the case of SB 8, you had a law that is clearly unconstitutional under Supreme Court precedent. There was no question that if the law were allowed to stand, irreparable harm would be done to countless Texans who would be denied reproductive health care. Granting an emergency injunction to stay the law while lower court proceedings proceeded would have been an appropriate use of the shadow docket. Yet, on August 30th, the court did nothing as the clock struck midnight and Texas's law went into effect. Only later the next night did the court issue a one-paragraph opinion saying they had declined to stay the law because of its complex and novel procedural questions. In her dissent, Justice Sotomayor made clear what happened. She said, quote, "The Supreme Court has rewarded the state's effort to delay federal review of a plainly unconstitutional statute enacted in disregard of the court's precedents through procedural entanglements of the state's own creation." In other words, the SB 8 scheme worked. This may sound like some abstract legal debate. It's not. The court's handling of SB 8 had a dramatic real-world impact. There are millions of people who last month could not exercise their fundamental reproductive rights in Texas. They could before, and now they can't. We now have 2 dangerous new precedents to contend with. First, with SB 8, Texas has created a model to undermine constitutional rights by using bounty hunter enforcement schemes. We are already seeing lawmakers in other states racing to copy that model. That should trouble anyone who cares about constitutional rights and orderly enforcement. Second, the Supreme Court has now shown that it's willing to allow even facially unconstitutional laws to take effect when the law is aligned with certain ideological preferences. Constitutional rights for millions of Americans should not be stripped away in the dark of night, even at the Supreme Court. That is exactly what happened when the architects of SB 8 did their bidding, when the Supreme Court did their bidding at midnight on September 1st, and the Supreme Court allowed it. It's already too late for many Texans whose rights have been suspended and who have been forced to leave the state to seek reproductive health care the Constitution has already guaranteed them. But it is not too late for the rest of the country and the court to change course.